So let's understand now about the independent director. So independent director is a special kind of director. These types of companies required to have mandatorily appoint a independent director. So let's talk about independent director. It is mentioned under section 149, subsection 4 and rule 4. So every listed public company, here the word is listed public company. So every listed public company shall have at least 1/3 of the total number of directors as independent director. So suppose if a listed public company has 3 directors, at least one shall be independent director. And any fraction contained in this 1/3 means that suppose the number of directors were 5 in total. So obviously a fraction will be landing, when we'll calculate, it will be a fraction, right? So 1/3 will be calculated here in this way, that the fraction will be rounded off to 1. So at least 2 directors will be required in case the total number of directors are 5, then 2 should be ID. For a listed public company, the word is listed public company, right? Next, public companies. Public companies who are unlisted but who are complying with these provisions, these conditions, any of it, right? Either of it is complied, then or it's met, at least 2 independent directors need to be appointed. Paid up share capital should be greater than equals to 10 crore, or turnover greater than equals to 100 crore, or paid or aggregate means the average loans, debentures, deposit is more than 50 crores. Limits are important for the remembering purpose. So paid up share capital 10 crore or more, turnover 100 crore or more, aggregate loans, deposit, debenture more than 50 crore. Then these companies need to have minimum 2 independent director appointed. Where a company ceases to fulfill any of these 3 conditions, right? These conditions, if the company is not fulfilling for 3 consecutive years, so continuous 3 years need to be seen that these conditions are not complied, then only the companies can lay off their IDs, and they don't require to appoint IDs anymore until such time as it meets any such condition again. And suppose the independent directors are required in various committees of the board as well, right? And they have other different agenda also. So obviously the composition of the audit committee, or for requirement of any other purpose or other compliances of this act or other act, higher number of independent directors are required, then obviously the company shall be appointing the higher number of IDs, means more than 2 IDs will be appointed in that case, right? And if there is any intermittent vacancy in case of independent director's position, then it will be filled up by the board at the earliest, but not later than next immediate board meeting, or 3 months from the date of vacancy, whichever is later. The unlisted companies, unlisted public companies, these unlisted public companies are exempted from the requirement of appointment of minimum 2 IDs. So they don't require to appoint the IDs, even though the limits are breached. First one is JV, joint venture. Other one is wholly owned subsidiary and the dormant company. Just the names are important for the exam purpose. We can analyze from this that private companies also need no requirement of IDs there in private company as well. Now we are understanding about the subsection 6, which has the 6 conditions required to become an independent director in any company, right? So criteria of independence mentioned under section 149 subsection 6, and we easy to remember 6 conditions, and subsection is also 6. So 149 subsection 6 is important section number as well, which lays down the criteria of independence. So independent director status is a non-executive director, plus he is complying with this subsection 6 conditions. So this managing director or whole-time director, they are executive directors. So obviously they cannot become an ID. And nominee director being a non-executive director but appointed for a certain different purpose. So obviously he cannot be appointed as an independent director. So a person has to become independent director, then he has to comply with the 6 conditions. First one is, who is, in the opinion of the board, is a person of integrity and possesses relevant expertise and experience. Given under Rule 5, Rule 5 specifies the qualification to become an independent director. An independent director is a person of integrity, and he is having the skill, relevant skill, knowledge, experience in the one or more fields which are mentioned under Rule 5, such as finance, law, management, sales, marketing, technical fields like engineering and other science field, and apart from that, any other field in which the company is doing its business. So if a company is a space exploration company, then obviously they will be requiring the aeronautical engineers or obviously space scientists. So they can become the independent director, having relevant knowledge, skill, and obviously experience in that specific field in which the company is working. So obviously the company can take the services of this director and can use him and use his advices and his services so that they can grow their business. So that's the purpose of appointing the independent director. So the board has to confirm that this particular person is having the relevant skills, experience, and knowledge. This person, the proposed ID, is not a promoter, was not a promoter, and is not a promoter of the company or HSA. And also, he is not related to promoter or directors of the company or HSA. There is no pecuniary relationship other than the remuneration as such, director, or having a transaction not more than 10% of his total income. So whenever a transaction is happening other than anything which is the director is getting apart from the remuneration, ID should not get it, right? And if he's getting or any transaction is happening between the ID or the company or HSA or promoter or director during the timeline, that is the two immediately preceding financial year or during the current financial year, it should be less than 10% of his total income. None of his relatives. So relatives means the relative of the proposed ID, right? So relatives should not be holding these positions in the company or these states. First one is the relative is not holding any security of or interest in the company or its HSA or during the two immediately preceding financial year or during the current financial. So the shares or securities, the relative should not be holding that. And if they are holding also, the cap is there. It should be less than 50 lakh rupees face value or 2% of the paid up share capital of the company or HSA. Indebtedness, the relative is taken any loan from the company or HSA or promoter or director, it should be less than 50 lakh rupees. Or this loan is taken during the two immediately preceding financial year or in the current financial year. Or relative is not taken the indebted, he is not indebted, or he has not taken any loan, or he has no any other kind of indebtedness with the company or HSA or promoter or director, but he has given the guarantee or he has provided any security in connection with the indebtedness of any third person who is indebted to the company or promoter or director or HSA, and that amount of loan or indebtedness is more than 50 lakh rupees in during the two immediately preceding financial year or during the current financial year. Apart from these three conditions, any other transaction can happen between the relative and the from company HSA, right? So it should be less than 2% of the gross turnover of the company or total income. We need to check this limit individually as well, right? And also in combination. It should be in combination less than 2% of the gross turnover or the total income. Fifth condition speaks about the both the things need to be seen, the person himself and his relative's situation, right? So person total restriction is there. The person should not be the KMP in past also or not presently a KMP in the company or HSA, right? Or he should also not be the employee in the company or HSA in any of the three preceding financial year, immediately preceding the financial year in which he is supposed to be appointed as an independent director. Next, for the relative stake, obviously the relative is totally restricted that the relative should not be the KMP. Not presently or in past also, he's not a KMP, right? But a relative can be a normal employer in the company. Now coming to these audit forms, auditors like statutory auditors, chartered accountant firms, company secretary in practice, or the cost accountants audit firms, right? So these audit firms, the employees of these firms or proprietor or partners of these firms, in any of the three immediately preceding financial year, they have done the audit for this company or HSA, then these employees, promoters, or partners shall not be allowed to become independent director. Legal or consulting firm who has given the legal advice or consulting advice to the company or HSA and deriving more than 10% of his gross turnover from the company or HSA. So suppose if the legal firm's total income, annual income or total income is 1 lakh rupees, then more than 10% means suppose 20,000 rupees the legal firm is getting just from this company. Then obviously their employees, promoters, partners shall not be allowed to become the independent director there in the company or HSA. The person himself, together with his relative, is holding more than 2% of the total voting power in the company, then also not allowed. The CEO or the director of the NPO, non-profit organization, who is receiving donation or receipts any other way, right, CSR purpose or any other purpose, receipts are being received from the company or its promoter or director or its HSA, right? It should be less than 25% annually. So if the total receipt of the NPO or non-profit organization or some NGO is less, it's suppose 1 lakh rupees, right? And it is NPO is receiving 30,000 from this company or its promoter, then obviously it is more than 25% of the limit. It is breaching that. So obviously NPO's head will be biased in this case. He will not be appointed as an independent director. Or suppose the NPO or the person, right, the head of NPO, chief executive director, is holding 2% or more total voting power in the company, then also not allowed. Fifth condition says any other qualification as may be prescribed. Government has prescribed the condition under Rule 6. So it's a newly amended rule, right? On 1st of December 2000, from 1st of December, with effect from 1st of December 2019, with the help of this Fifth Amendment, the rule has been amended. So a 13 months time was also given to the present IDs who are actually working in the companies, right, as on this date, that is 1st of December 2019, to comply with this provision. So what this provision speaks about is who actually is presently appointed as ID at this date or who want to become ID after this date have to mandatorily online register themselves with this institute, that is the Institute of Corporate Affairs, situated at Manesar, Haryana. So here, this institute is being given a responsibility from the ministry that this institute will be maintaining and creating the data bank for these directors, that is independent directors. So any corporate require any ID, they can approach this institute, access the data bank, check the qualification and the profile of the person, and can approach that person individually and can be agreed upon between the parties if they want, and he is eligible, he is willing, can be appointed as an independent director. One or other thing is that the registration for this institute can be voluntary, means mandatory for these people, but it is the choice of the person, right? For 1 year, for 5 year, or for lifetime, for how many years he wants to become the member of this institute, right? So if a person does not have a DIN, also can apply voluntarily to the institute for including his name in the data bank. Afterwards he can take a DIN whenever he gets the call from the company for the appointment. Application for renewal has to be done within a period of 30 days from the date of expiry of the period up to which the name has been included in the data bank, failing which the name will be removed. And obviously if the name is removed, he cannot become the ID anywhere. And the person who is a lifetime member paid the lifetime fees as well. He doesn't require any renewal thing. And in the declaration which is given under section 149 subsection 7, the ID will be complying with, he is complying with this rule and he is a member of this institute, he has to mention in such declaration. Within 2 years from the date of including his name in the data bank, institute will conduct the exam, right? So within 2 years time, he has to pass this exam. All the individuals, all the independent directors have to pass this exam. That is online proficiency self-assessment test, right? It's a multiple choice based questions are asked and number of attempts are unlimited. passing percentage is more than 50% in aggregate. And if the person failed to perform well in this exam and cannot pass, then his name will be removed. He cannot become ID. But few individuals who have experience are exempted from this exam, right? Though they have to register in the data bank with this institute, but they don't have to pass the exam because they're well experienced and they know the work. So more than 3 years experience of a person has as a director or KMP in a listed public company or in an unlisted public company having the paid up share capital of more than 10 crore rupees or greater than equals to 10 crore rupees, or he's a director or KMP in the body corporate listed in on any recognized stock exchange, or body corporates incorporated outside India, foreign companies or foreign body corporates having paid up share capital of greater than equals to USD 2 million, or statutory corporation set up under the Act of Parliament or any other state legislatures like LIC or a Food Corporation of India, which are carrying commercial businesses, right? So these companies, corporations, directors or KMPs are not required to give the exam, right? They're exempted. And one more thing, that India being a part or a member of Financial Action Task Force, so obviously the other countries who are the members of FATF, FATF is a global body which is entrusted with the work of stopping the money laundering activities around the globe and also the terror financing activities. So here, the FATF member countries, right? India is a part of FATF and it's headquartered at France, Paris, FATF. So other member countries, right? And the country's regulator, that is the Securities Market Regulator, we have SEBI. So our SEBI, that is Securities Exchange Board of India, the regulator of financial, I would say the regulator of the securities market, regulator, SEBI, is registered with this international body, that is the International Organization of Securities Commission, where every obviously the members of this commission the countries regulators are registered, right? So SEBI is a member of that. So if a country is a FATF member country plus the country's regulator, the securities market regulator like our SEBI, is registered with this International Organization of Securities Commission, then the companies who are there incorporated under that in these countries shall be exempted. The directors will be exempted if they have more than 3 years experience. Next, these are the government officials, very high rank officers, right? And having more than 3 years experience in the field of handling the corporate law affairs, securities law, and economic laws, they are also exempted, right? So these are officers and IAS officers who are working with these ministries and above the level pay scale or above the post of director or above, right? It's a highly prestigious post, right? And very much experience are required to become a director there, right? So it's a director or above in Ministry of Corporate Affairs, right? Or Ministry of Finance, Ministry of Commerce, Industry, and Ministry of Heavy Industry, Public Enterprises. They don't require to give this exam. Chief Financial Manager, that is the CGM or above post in these regulatory bodies. So India has many regulatory bodies. So different types of markets regulators and different domain related regulators are there. So SEBI is a securities market regulator. RBI is a financial money market regulator, right? So financial market and securities market regulator is SEBI in India. RBI is a regulator. It's a financial not, but it's a money market regulator. RBI. IRDAI is a insurance regulator headquartered at Hyderabad. And PFRDA is a pension fund regulator, right? And insurance regulatory exchange board is there. So these CGM or these officers working with these regulatory bodies, they are well experienced in these acts, rules, right? So they don't require to give the exam. 3 years will be counted, right? Like if a person is associated with 2 or more companies or body corporate or statutory corporation at the same time, then also we'll count it as one, because we are judging the career of that person, that for how many long time he was associated with these activities. Every individual, every ID has to give in the first board meeting when he participates, the declaration under section 149, subsection 7, that he is complying with the criteria of independence. And in every year, annual compliance is their first board meeting when or whenever there is any change in the circumstances, the ID has to give the declaration. ID has to fulfill the Schedule 4, which is the code of conduct of the independent director. And ID shall not be eligible for stock exchange because we have just learned that ID should not be controlling the voting power in the company, right? It should be less than 2%. So obviously, why the ID will be given stock exchange, stock options, right? ID can get only three things: sitting fees, reimbursement of expenses for participation in the board meeting, right, and other meetings, and profit related commission as may be approved by the members. Term of ID. One term equals to 5 years, maximum 5 years. It can be less than 5 years also, at the discretion of the company and the board. IDs are eligible for reappointment by passing special resolution, and the disclosure of such appointments will be done in the board's report. ID shall be holding maximum for or can engage maximum for the 2 years, two consecutive terms, right? Two consecutive terms, ID can be associated with the company, and one term maximum is of 5 years. So maximum 10 years, we can say. Or it can be less than 10 also, as per the discretion of the company and the board. Independent directors thereafter has to step down, and for next 3 years, obviously, they should not be appointed in or be associated with any other company or in any other in the company in any other capacity, be it directly or indirectly. Then only they are again eligible for fresh appointment. ID's term is fixed, so obviously ID shall not be retiring by rotation. And independent director and the non-executive director who are not promoters or who are not KMPs, so obviously they should not be held liable for all the affairs or all the non-compliances of the company. So whichever matter which is being done with their knowledge, with their consent, that for that only they will be held responsible by the regulators. They will not be dragged to all the affairs of the company like the executive team will be dragged. So independent directors are protected with this subsection, that only the acts or omissions or commissions which are done with his consent or connivance, to which he will be liable, not for all the matters. So we have learned about the independent director and the various provisions with respect to independent director. Hope everyone has understood. Thank you for your patient listening.